For pronouncement of judgment, item 1.
The petition is dismissed at the motion stage. Yes.
May it pleases your lordship. My lord, item number 29 and 43.
Twenty-nine.
And 43, lordship.
Yes.
And with the consent of the other side, I seek accommodation for the day, lordship.
29.
29 and 43, lordship.
43. But it goes for 2 weeks. Says a representative, the prayer made by land counsel for the petitioner, list after 2 weeks on date to be fixed by the registry.
Deeply.
Similar item number 26. I'm feeling not
Item
well.
number
26 lots of.
26.
I'm feeling not well, lots of that's why.
Okay, save. 26.
Deep level.
Maybe. Item number 24, my lord. At 24, I'm paying for adjournment, my lord.
24.
24,
Okay.
my lord. An advocate, Mr. M. Samuel, is out of state.
24. And how is Dr. Ahmed now?
Now, my lord, stable, my lord. He is stable, my
He's
lord.
stable. Okay. Yes.
Yes, your lordship, I beg to mention item 32 of today's list, your lordship. You have to obtain certain instructions. I have informed the government.
$32.
Yes, your lordship.
You're for the petitioner.
Yes, your lordship.
Okay. Same order.
Oblige you.
May it please your lordship, I beg to mention item number 37, your lordship. Kindly pass over the matter for the day. Oblige.
Daily list, item 1 for motion.
May please your lord. For the timing, my lord. My senior is coming, my lord, on the way. First.
Item 2.
May I please list?
in opinion is at page 40, Lordship, dated 21/3/2023. That is the case. I exhibited documents, exhibit 1, 2, 3, 4, 5 is up to 10, Lordship. 1966 voter list of my grandfather, and 1970 of my grandfather, father, mother, then 85, exhibit 3, my father, mother, brothers, then exhibit 4, 1989, parents, brothers' name, then 1997, my parents' name appeared, the exhibit 5, exhibit 6, voter list 2008, my father's name, and exhibit 7, voter list, my father's and brother's name was exhibit 7, Lordship. Exhibit 8, voter list 1985, my name appeared along with husband. I adduced evidence as DW1, and my brother also adduced evidence on behalf of me as DW2. And exhibit 10 is the linked document, Lordship, that is CITA. After death of my father, my name along with a family member, that my brother, sister, that also appeared. The tribunal ignored the same, Lordship, only interpreted some documents. No evidence has been considered at all. And the written statement, I have been stated in details by family tree regarding Lordships as well as discrimination MLA. I also challenge that there is no inquiry at all. That is also my stated in my written statement, Lordship. They never visited my house also.
We find that this has been heard earlier. So we take it up with for disposal in the admission column after 2 weeks.
Lordship,
We issue a notice and then pick up the matter at the admission stage. This is motion and the records have come.
At this stage, some protection may be given, Lordship. But that time, LCR was called for, Lordship. There was an direction on receipt of my intimate consider, Lordship. Is it about, I am 50s now. My date of birth is 1956, Lordship. Age at level of 15 years citizen. Now 74 years, lady, Lordship.
But Mr. F. U. Borgia, Current Counsel for the petitioner. This writ petition under Article 226 of the Constitution of India was filed assailing the opinion rendered by the Foreigners Tribunal, Borpeta 11/840. The matter was earlier heard by a coordinate bench. The PCR have been received as called for. The matter will be now listed for admission after 2 weeks. Yes. 9 notice issue. Issue notice returnable in 2 weeks. Extra copies, 2 days. The prayer for bail is opposed by the learned planning council for the FT matters. However, on going through the contents of the writ petition and considering the age of the petitioner, we are inclined to grant bail to the petitioner, namely on failure to be given. Please the matter up.
Appear before the SPP within a period of
SP border Borpeta.
worship.
(27/8).
Oblige.
Item 3.
Lordship, the matter may be password for the time being.
I have taken instruction, madam. Into I said. I have received.
Item 4.
May I please? Lordship, here in this case, Lordship, petitioner is the mother of the detainee, Lordship. She was taken by the.
We have not been served with copies in 4, 5, and 6, Lordship. Though they have made us parties, 4 and 5, Lordship. And we have nothing. Check the record.
Yes, Lord.
Four and 5, Lordship.
Yes, Lordship. Lordship, she was taken. Earlier, she was in detention camp. Later on, after effect of judgment, she has been released. And recently, on 24th May.
Who is under detention? Your mother?
Mother, Lord.
Huh. The petitioner has submitted that his mother, namely Musammat Parishkar Begum,
Yes,
has been taken into custody on when
24th May.
24/5/2025. And since then, her whereabouts are unknown. Accordingly, this writ petition has been filed under Article 226 of the Constitution of India. From the materials available on record, it appears that on an earlier occasion, the mother of the petitioner had been declared to be a foreigner of the post-1971 stream by an opinion rendered on 25/7/2017, and she had challenged the same by filing WPC number 5519 of 2017. Upon consideration, this court had remanded the matter back to the tribunal by order dated 26/2/2019, and thereafter a fresh opinion was rendered on 26/4/2019, upholding the earlier opinion regarding the nationality of the mother of the petitioner. The mother of the petitioner was thereafter kept in a detention center. And on the basis of the orders passed by the Honorable Apex Court in WPC 1045 of 2018, the mother of the petitioner was granted bail, was released on bail with certain conditions. However, on 24/5/2025, upon her appearance before the Hojai PS, she was detained and her whereabouts are now unknown. We request the Learned Standing Council, FT Matters, to obtain information about the place where the mother of the petitioner is presently lodged, if not already deported. And if the mother of the petitioner has been deported, he shall provide information as to the place from which the mother of the petitioner was deported and the manner of deportation. It has been submitted that extra copies, copies of the writ petition had not been submitted to the Standing Council for FT Matters. Counsel for the petition undertakes to supply copies within the day
What's up
itself.
there?
List on
Next week, Lordship. Next Monday.
13/8.
11th.
11/8.
5 is also similar, Lordship, only the date of the opinion is different.
I think there is only one order of the tribunal. There was no writ petition for the second person.
Lordship,
In the earlier case, there was a writ petition remanding the matter back.
yes,
Here, there is no such writ.
yes, here also, Lordship,
Please.
but opinion is passed on 10/6/2025, Lord. Prior to that, Lordship, she was been taken in custody. Page 21.
Show me the High Court order remanding the matter back.
No, there is no High Court order.
That is what I'm saying. There is only one opinion.
One opinion.
On the basis of that, now she has been detained.
Yes,
Lordship, it's an ex parte opinion.
ex-party opinion, and it's passed on 10/6/25. Mother of the petitioner.
Heard Mr. T. A. Chaudhary for the petitioner. The reference means the same.
Name of your mother?
Lordship is Misma Khatun.
Hmm?
Misma Khatun.
Oh, I do. Really.
It has been submitted that the mother of the petitioner, who was arraigned as proceeding number 2 in page 21 of Cyber. The mother of the petitioner has been picked up by the, it has been alleged that the mother of the petitioner has been picked up by the Hojai police on 24/5/2025, and since then her whereabouts are not known. Hence this petition under Article 226 of the Constitution of India. From the materials available on record, it is seen that the mother of the petitioner was declared to be a foreigner of the post 1971 period, along with 3 other persons. The mother of the petitioner was detained in the detention center but was released on bail after the orders passed by the Honorable Apex Court in WPC number 1045 of 2018, with conditions to appear before the Hojai police station once every week. On her appearance on 24/5/2025, she was detained and thereafter her whereabouts are not known. There is no material on record to show say, since the petitioner projects that the whereabouts of his mother is not known, we request the learned standing counsel for the FD matter to obtain information as to the place where the mother of the petitioner is presently lodged, if not already deported, and if deported, the date and manner of such deportation be informed. The learned standing counsel for the FD is permitted to send a downloaded copy of this order to the concerned authorities to enable her to obtain information and inform the court accordingly. It has been also submitted that copies of the writ petition has not been furnished to the standing counsel for FD matters. The learned counsel for the petitioner undertakes to supply the same during the course of the day. List on.
Same date, Lordship.
List on 11.
11.
Hello.
Item 6,
This court Lordship, PCR was called.
Not received, I think.
Ms. Verma, you were required to produce the record of order 14/7
Should you give me some time? Mr. Sharma has not come. He will.
After
have-
some
He
time.
may have the records with
After
him
some
now.
time.
Yes, Lordship. Time being.
After some time.
Governmental copies.
Item 7,
May I please, your lordship? Lordship, in this case, your lordship, I am challenging the impugned order which is on page number 34, annexure number 13, your lordship.
You have to wait for some time for bail, 2023 opinion.
Yes, I have made the corrections, your lordship.
Heard Ms. P. Das, learned counsel for the petitioner. By preparing this writ petition under Article 226 of the Constitution of India, the petitioner has sought to assail the opinion rendered by the member Foreigners Tribunal, page 34 of the same. Issue notice returnable on requisite copies of the requisite extra copies of the writ petition be furnished to the learned standing council within 2 working days. Let the relevant records be called for from the Foreigners Tribunal by usual process as well as email. Prayer for bail shall
Yes, lordship, can I pray for the interim, your lordship, because only he may be protected, your lordship, during the pendency of this case, your lordship.
2023 opinion.
Yes,
We are protecting you from deportation. Only from deportation.
yes, yes, that will do, your lordship.
Prayer for bail will be considered on the next date. However, in the meantime, if the petitioner is apprehended, he shall not be deported out of the country without order of the court. Petitioner will produce a certified copy of the order to the Superintendent of Police, Kamruk Metro. Deputy Commissioner of Police.
Karimganj, your lordship. The case is from Karimganj, your lordship.
Page 34. FD Kamruk Metro.
Kamrup, lordship, it was in Kamrup, Metro.
Yes, sir, pardon me, lordship, I'm the matron. No, your not no, your lordship.
It's a bit loud, type.
You have to make your corrections in the petition, otherwise it will be
Lordship,
an error on record. You are handling the, you are trying to argue the fate of a person who's facing deportation or a declaration that he's not an Indian citizen, right? Prior to this occasion, you had to correct typographical errors. True?
can I then?
Now
please
you are-
put
you
the
have to correct the-
correction of multiple errors, whatever in the.
How can you do that without a I
Can
or
we
something?
withdraw it with the liberty of filing then?
Something has to be done because you see even at on my page 5,
Yes, your lordship.
it is SP Boda Kamruk Metro. We
Yes,
cannot know if it's such an authority here.
I will withdraw it. Kindly let me withdraw it with the liberty to file again, your lordship. Within 1 week, I'll file it.
Counsel for the petitioner, please, for liber, to withdraw this petition with liberty to file afresh in view of certain inadvertent mistakes. Allowed with liberty as paid for. Be careful.
Deeply obliged.
time being item 3.
My lord, on that day, your location you have traced out, yes. Thelamara police immediately given us information, probably when message gone there. Ask father, you proceed to Delhi, such and such, and he was found, my lord.
I have received it.
Yes, but he is seriously ill, my lord.
No, no, my lord, there is no, he, my lord, leave the house, he is presently residing in Delhi, working in so and so, and he voluntarily left his parental home due to the mental harassment by his father.
That is your state.
That-
But he is
that
coming
is
with father.
stated by police, my lord.
Father informed me from Delhi.
Father harassed his son. Then even his daughter also left his house after.
That day you were located in a right place.
How he left, my lord? He is engineer, my lord. Last, you'll also see, last. He also stated that my lord, his mother expired due to some medical problem, and he says that his father not take any care. That is also his care, my lord.
আমি দিল্লির পরে খবর করি আই আছে আই গো গুয়াহাটি পালে গুয়াহাটি
Saída banana. Por aqui.
Then we have to just close it.
Yes,
We record this and close
yes,
it.
yes.
And
But I am obliged because of your.
last prayer also, last line also you will also.
We have seen that. It's very sad.
31-7.
It's
His
very-
daughter also my lord left.
Very sad. Still.
Yeah, no, yes, yes. I know, my board will line up. You got I'm phone for you. I think that more area for it.
এই কথাটা বুঝে ওষুধ ছেলে আমরা জানিতে লাগে
Heard Mr. S.C. Viswas, learned counsel for the petitioner. Also heard Mr. P. Sharma, learned additional senior government advocate, appearing for the respondents. The writ petition was initiated by the petitioner, alleging that his son, Shri Vivek Das, was missing from his home since prior to sunrise on 14/1/2025. It was further alleged that despite searches made, the son of the petitioner could not be traced and the
লক্ষ্মীনগরে পাই
on 3rd of February 2025, the father of the petitioner had lodged an FIR. Mr. Sharma, can you just clarify at page 23?
yes page 23
Yes, come to.
Page 23, the FIR is of 3rd of February 2025.
exactly
And on your report, on 19/1/2025, is there another FIR? Second paragraph from the top.
very good very good no
Girl also were left. Second FIR, my perhaps for daughter. Daughter also left. That person also.
The photo at page 23 is for the son.
yes
How many FIRs have you lost? Has your client lost?
my only one affair for son for daughter she is the in touch with us my lord.
Daughter also left.
The petitioner projects that on 3rd of February 2025, an FIR was lodged to the effect that his son, aged about 26-year-old, was missing from home before sunrise on 14/1/2025. Full stop. It was also alleged that all efforts for his search did not yield result. When the son of the petitioner could not be traced thereafter, he filed the present writ petition on 3rd of July 2025 praying for appropriate orders to the authorities to take necessary steps to trace out the missing son and to produce him before the honorable court. Full stop. On 21/7/2025, this court had observed that a search made in the internet revealed that the phone number of the petitioner could be traced to a certain location and certain location that is, it will be 21 second. A mention therein, and thereafter a request was made to the learned additional senior government advocate to obtain instructions from the officer in charge of Telamara police station on the issue. Next paragraph. Today, when the matter is taken up, the learned additional senior government advocate has produced a report dated 1/8/2025, which in brief described the process undertaken by the Telamara police station pursuant to receipt of the FIR, and it has been stated that on contact being made by the police station to the son of the petitioner, he initially did not answer the calls, but later called from an unknown number. Full stop. The report states that the son of the petitioner has been residing in Delhi and that he had voluntarily left his parental home. Full stop. We have inquired from Mr. Biswas, legal counsel for the petitioner, as to whether the petitioner has been able to contact his son thereafter, and he answers in the affirmative.
He's coming with father. He's returning with father.
He answers in the affirmative and submits that father and son have been reunited and on their way
He
home.
was also DSP, my lord. Father was also DSP.
Retired DSP.
Retired DSP, and he was a specialist on encounter in our area.
Why you are saying all this? It is your word.
Specialist.
His work, my lord.
Discipline.
Discipline.
And are returning home.
Was a specialist.
In above view of the matter, Mr. Biswas submits that the writ petition may be closed.
Yes.
Ordered accordingly.
Yes.
Writ petition shall stand closed.
My lord, the latitude and longitude that your lordship has given here is also given by the IO here.
That in a record, maybe.
Yes.
Even details, I even telephone in my lord, but that person also DSP, and he was very well-known DSP at that time.
I just have a bad habit, that's all.
Well, item 1 is also there, my lord. Yes.
You were required to produce some.
Yes, I brought it. My lord asked me to bring this original one.
Item 1,
Yes. Even then, you could not put it in document. No, Home Minister has given us not in the parliament the other day. 2 days ago, that all the rules will be given, blanket will be. No question of. No question. So where the case is disposed of in that line.
I will play.
Kind of. Apna point. I'm going. अच्छा
Lordship has got the notification of amendment like that. This matter can be disposed of on those lines, Lordship. The petitioners can avail the benefit of the Citizenship Amendment Act, Lordship. Yes, Lordship. The opinion, if Lordship comes to the opinion, although we have found for religious persecution, I've seen the
yes yes yes. But that suggestion your lordship is always giving us. We have seen. But problem is that all the documents they are required in the car is
Lordship
not available
now,
with them.
Lordship now,
Yes. Sure. Give me some time then. Yes. Well, my friend wants to submit. But what the other day, Honorable Home Minister of India has announced in the parliament that henceforth for Hindu people, no documents will be there, but blanket citizenship will be given. Yes, yes.
Lordship, it is, if Lordship comes to this amendment, that Lordship, it is very clearly written here only, clause 2, Lordship. In the Citizenship Act 1955, herein referred to as the Principal Act in Section 2 in subsection 2 and 2, provided that any person
Yes, yes. Very true.
six A section of Lordship.
Well, not Friday, They give me at least 10 days time. I have to again bring this lady. Ten days time I'll give an. I'm giving you money. Let it run 12 minutes. It's a 3 days. Yes, yes.
Like either 11th or 18th lordship, 13, 14.
I'll get it back by 15 August, madam. Any day. Obliged. Yes, I'll take.
No, I have given this lordship for, I thought lordship may need it. Oh, this document, okay. I thought the notification.
It's not a copy from it.
It is on WhatsApp or didn't, no? I think it okay. After the, oh, it will go to 2019 Amendment Act. No, what to put it? But the height is make it.
From high video. It was one. Obligement.
Item 8,
Minor factor. Not to the different living local. हाँ ऐसे राहिले कन्फ्युज
There's 106 left. Hundred six left. 2022. An Ahmed. Better.
When you are drafting a writ petition, please mind your language. There are certain words we may take very offense of not only the court, but also the state will take a huge offense of that. In page 6, paragraph I, you are saying that the state has indecently made this reference. Choose your words very carefully. Choose your words very carefully. Can a state be indecent? Can. Yes. Very good. Now, please explain to us how the state can be indecent. We have already put a question of maintainability. We'll decide it here. Please sustain your submission that the state was indecent.
Yes,
One
the statement is
fifty-four is gone, lordship, now it's come to ABCD. Lordship petition is also marked as ABCD.
also in the type of lordship in the WS law. This statement is in the WS.
No, in the written statement it says inter alia. So this is a part of written statement.
Written.
ABCD.
They just,
Read
because sometimes there are more harsh words, lordship, more harsh words.
Item 9.
Maybe lot. Inform order test 87. 87. 87. You can access 16.
But Mr. H. Ali, learned counsel for the petitioner. Also, the petitioner has preferred this petition under Article 226 of the Constitution of India, selling the opinion rendered by the member foreigners tribunal, 3rd Nagaon, page 867. Issue notice returnable in 4 weeks. Requisite extra copies be supplied to the pending counsel for the respondents within 2 working days. Relevant records called for. The prayer for bail has been objected by the learned standing counsel for FP matters. However, in view of the projection made in the writ petition, we are inclined to grant bail to the petitioner in the following conditions. To go
SP Nagaon.
SP Nagaon, SP Court of Nagaon. Failure to appear the matter after 4 weeks or it's PCR.
Well obliged.
Item 10,
Yeah, it's no. Lordship, page 23 is the order, Lordship, ex parte order. No notice was served upon me, Lordship. I am the resident of Jaipur, Lordship, and notice was served upon on A. Samar of Bismuth, Monbury, Lordship.
Lordship, let the LCR come before Lordship gives him interim protection. This is Lordship at 22. Yes, Lordship. Hence the process server had put the seal notice on this. My concern was what address you had given in the inquiry, Lordship, at that point of time. Yes, but he never informed Lordship. He must not have informed. Service of notice, if we go to that, it is, but did he inform before leaving Lordship? How, if there is no information, where would this notice be? Lordship, let the records be called. But if he's not there, yes, putting it in the Raubura's offices, it doesn't go with the procedure. Yes, Lordship.
Yes, ma'am. Must
item 11,
May it please your Lordship. My Lord, in order at page 50, here, my Lord, the petition was declared upstream 66 to 71. And he has in the meantime registered document I have also annexed, my Lord. So, my Lord, at this stage, he challenge is only to the extent of modification of the Tribunal order. He ought to have been declared as a citizen, but declared as a steamed finance. He already registered, my Lord, registered documents. I have also annexed in the writ petition. My Lord, my Lord, page 56, registered, my Lord, page 56. Parents are voter in 66, 70. My lord, at least 56. 6, annex are 15.
Heard Mr. A.R. Sikdar, learned counsel for the petitioner. Also at Swensu. By preparing this writ petition under Article 226 of the Constitution of India, petitioner has essayed the opinion dated 23/5/2025, page 57, whereby the tribunal has opined that the petitioner is a foreigner of illegal immigrant who entered India within bracket Assam between 1966 to 1971 from the specified territory without any valid documents. Full stop. The tribunal had also required the petitioner to register herself in accordance with Rule 19 of the Citizenship Rules 2009. Full stop. Mr. Sikdar submits that following the orders of the tribunal, the petitioner has registered herself as mandated by law, but is aggrieved with the declaration that she is an illegal immigrant of the aforesaid period. Full stop. Issue notice returnable in 4 weeks. Requisite extra copies be served
My lord,
in 2 working days.
my lord. Bail is not required in this case.
Relevant records we call for from the
Right.
Finance Tribunal by the usual process. List on receipt of the records or after 4 weeks.
Develop, pleasure.
Item 12,
May it please your lordships. Thus, I am led the senior counsel, Mr. I. Chaudhary, in this matter. He is on legs in another court. Can it be passed over for the time being, lords? He'll be here any minute.
Artin.
May it please your lordship. into the order case 40 also, petition opinion, dated 29, 2024. 40 lot, 40. Dated 29, 2020. Highly approved. Upright.
Item 14,
The impugned order, page 38, 18/3/23. One. My lord, my lord.
2 working days, you'll give the
My lord.
copy. Let the relevant records be called for from the concerned tribunal. Prayer for bail shall be considered from the next returnable date. However, in the meantime, if the petitioner is apprehended, he shall not be deported without orders of this court. Petitioner shall produce a certified copy of the orders of this court before the Superintendent of Police Border Bojali,
Grateful, ma'am.
list on 5/9.
Grateful, ma'am.
item 15,
Yes, please, sir. My lord, the impugned order is at place number 85, please.
5th of September. Item 16.
May I please will, my lord, impugn opinion, my lord, page 114 impugn opinion, my lord, in fact, my lord, petitioner has come before this court lately, my lord, because of his poverty, my lord.
Lordship responding phone needs to be corrected. Lordship, not this one. I was looking at the other one. The next one, Lordship, I'm sorry. One fast one, I go. 16 or 17 times. No, ठीक है साहब, ना ठीक है. Sorry. मैं 17 size.
Heard Mr.
A Manna.
A. Manaf, learned counsel for the petitioner. Also heard counsel for the respondents. The petitioner has sought to assail the opinion dated 4/24/1/2020. Passed by page 1140. By preparing this writ petition under Article 226 of the Constitution of India. Issue notice returnable by 5/9/2025. The issue of maintainability of the writ petition is kept open. Requisite extra copies of the writ petition be served on the counsel for the respondents during the within 2 working days. Relevant records be called for. Prayer for bail will be considered on the next returnable date. However, if the petitioner is apprehended in the interregnum, she shall not be deported without leave, without orders of this court. Petitioner will produce a certified copy of the order of this court before the SP border,
Nalbari.
Huh?
Nalbari.
Nalbari. Based on 5/9.
Highly obliged.
Mata na, you see mata, 17.
Item 17.
This,
Button up your coat. I thought of the brand.
Lordship respondent 4 here needs to be corrected.
Page 4. Respondent number 4. Has to be the district commissioner, not the deputy commissioner. Correction of parties has to be done by filing an appropriate application or filing the new court that will memo party. Fresh application can I do? Right. Heard, Mr. Your name? Vivek Kejriwal. Heard, Mr. Vivek Kejriwal, learned counsel for the petitioner. And also heard so and so. It is observed that the respondent number 4 arrayed in the memo parties is wrongly nomenclatured. When a counsel for the petitioner makes a prayer to allow him to correct the same and file an amended cause title, the prayer is allowed. The amended post title depicting respondent number 4 as the district commissioner, Dibrugarh, Assam. Be filed by the petitioner within a period of 3 days. Matter be listed thereafter.
The question of law that arises in this matter is whether the recommendation of the commission would be binding. That has been answered by 3 different high courts. At this stage, my lord, I am praying for a notice.
Heard Mr. I. Chaudhary, learned senior counsel, appearing for the petitioner, assisted by S. Vishwakarma. S. Vishwakarma. By preparing this petition, the interference of this court has been sought for in the order dated 26/2/2024, passed by the respondent number 3
There are two orders, one. There is one of 14/11/23 and
Impugned orders there are 14/11/2023 and 26/2024 passed by the respondent number 3 exonerating two police officers in a disciplinary proceeding, although the petitioner commission had indicted them of violation of human rights and had recommended imposition of major penalty upon them. By its order dated 24/1/2023. Issue notice returnable in 4 weeks. Extra copies of the writ petition be furnished to the learned counsel for the respondents.
For 1, 2, and 3.
one with 4, 5, and 6 will have to take various purposes. 6 is pro forma.
Mr. Dinath accepts notice on behalf of respondents 1, 2, and 3. Steps by registered post be taken on respondents number 4 and 5 and 6 within a period of 1 week from today. List again on
Right.
The records of the disciplinary inquiry. Mr. Dinath, we request Mr. Dinath to call for the records of the inquiry proceeding.
Right.
Time being item 6 for motion.
No, Lordship.
You get directed you to get the record.
Yes, Lordship, perhaps Lordship, sorry, Lordship, perhaps I keep the Lordship next Monday, Lordship, actually brought it, Lordship.
Because he's saying that he is not the proceedee, somebody else
Yes,
is the
Lordship,
proceedee.
yes, yeah. Next Monday, Lordship, next Monday.
Both sides are represented. Mr. G. Sharma, the net standing counsel for the FP matters, is prayed for some more time to obtain the records as per order dated 14/7/2025. It is allowed list on 11/8/2025, by which time the records referred in the order dated 14/7/2025 be produced. Please send the requisition.
Yes, bro.
He does.
Heard Ms. B. Das, learned counsel for the petitioner. Also heard counsel for the respondents. By preferring this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 26/5/2025, page 62. Issue notice returnable in 4 weeks. Requisite extra copies of the writ petition be supplied to the learned counsel for the respondents within a period of 2 days. Let the relevant records be called for. The prayer for bail has been proposed by the learned counsel for the learned standing counsel for the FP matters. However, in view of the projection made in the writ petition, we are inclined to grant bail to the petitioner by providing that on her appearance before the SP border, Bongaigaon, on failure of the petitioner to appear, list the matter after 4 weeks or on receipt of the relevant records from the concerned tribunal.
Item 19.
May please. Well.
Fifty-four, Lordship, in opinion, dated 17/2024. 17/2024, dated. Is 50.
No, it's, no, it's. It's people. No, use it.
Yes, even I'm holding that same brief. Opinion letter. No, no.
24.
Then one, this must be different. It was new log out into it.
See. Mr. Bora, show her a
Two,
copy.
three.
Just
Same name, Lordship, there must be some case of mistaken identity.
number.
We are also holding the same brief, but same district,
same name, same district.
same
but for different
everything,
person.
same Lordship.
Okay, just show your copy to her. If name.
It was some ID. No, it's okay. We have a different one, Lordship. But the names are absolutely same, Lordship. Same with No, I to do that. Separate. Extra copy. Absolutely same name, everything, and tribunal also same.
He's praying for his family, he's praying for the family members.
No, there is we have filed a 6 petition,
Ah.
same family member.
Names are different in all of them? Or do
Names
you-
are different.
Oh.
One of her is already listed in the paper, item number 13. He is the petitioner's father, item number 10.
13, 1-3.
1.
HP border, Nogao.
No.
I did not copy.
Failure of the petitioner to list the matter after 4 weeks or on receipt of the records from tribunal.
Hello.
Just Mr. Bora. In this case.
In this case, one of the family member lordship, only 2013 declared as a not foreign.
In this case, two other persons were arrested of your family.
Yes, yes, yes. It's a stepmother and one wife of the one of the people. Wife, stepmother.
20.
Apply.
May please, your lordship, their opinion, lordship will find at page 60, dated 29/1/2025. Father is butchered in 1966, but thereafter father died. Mother was married to another person. He was brought up by grandparents. Then married. Mother was examined.
Heard Mr. A.R. Sikdar, learned counsel for the petitioner. Also heard the learned counsel for the respondents. The petitioner has sought to assail the order dated 29/1/2025. Issue notice returnable in 4 weeks. Requisite extra copies of the petition be served upon the counsel for the respondents within 2 working days. Let the relevant records be called for. The prayer for bail has been opposed by the learned standing counsel for FT matters. However, in view of the projection made in the writ petition, we are inclined to grant bail to the petitioner, namely Elliot Pintar, by providing that on her appearance before the Superintendent of Police,
Gwalpara.
Gwalpara, border Gwalpara, failure of the petitioner to list the matter after 4 weeks or on receipt of the records. Trial.
Apply.
Twenty-one.
May please, your lordship. My lord, page 59 is the impugned expert of the lordship.
Page
59. 59. And pursuant to this order, I am taken into custody, lordship.
your IA is for what?
I for bail, lordship. I am in custody, lordship.
In custody.
Only 5 dates I could not appear, lordship. Only 5 dates I could not appear. Only 5 dates I could not appear.
Miss Vama,
Yes, lordship.
can we request you to call to bring the records? He's in custody.
Lordship, if the records are there,
Opening is at page number
Page number 59, lordship.
59.
Yes, lord.
Is Borpeta. Or we should call it because these Independence Day programs will be there. Should we call it or it will be convenient for you to get it?
as lordship directs.
No, because this situation, because of this situation, we are asking you. Otherwise,
They will take some time to send after Independence Day, Lordship.
then we send it to
Registry.
requisition. That
Yes,
will be
Lordship.
easier then.
Expert order. Lordship. We are for a shorter date because I am in Khartoum.
The police establishment will be all engaged in the uh, Independence Day programs. And secondly, some law and order situation also. But
22 for admission.
Can this matter be taken tomorrow, day after tomorrow, Milo? Can this matter be taken tomorrow, day after tomorrow, Milo? Conducting counsel, Mr. HOD has some difficulties today now.
At two, you have value of property.
Prayer made by land council for the list on, make it tomorrow. Tomorrow, week. Fifth.
Obligement.
Please, your lordship. By filing this petition, excelling the opinion of the tribunal, my lord, tribunal order dated, my lord, 23/2018, lordship. Page number, my lord, 119. My lord, finding of the tribunal is start from, my lord, page number 122.
You may just hear Miss Verma, that this you are referring, since we won't be passing judicial order,
Yes,
let's speak to him and then tell him.
yes, Lordship. Lordship, please.
Next matter may be taken up. Next matter.
After some time.
Yes, lordship. This matter taken up after some time.
Okay.
Next matter may be.
Item 25.
May I please, your lordship? He wants to talk to his client.
I will take settlement from the client. lordship.
After a week,
After a week.
which says that. On the joint prayer made by the council for the petition as well as the expanding council for the FT matters, list on 11/8/2025. Okay,
Obliged.
you'll get by then.
Okay.
May I please, your
That
lordship?
was in 24.
Okay.
Okay.
May I please, your lordship? Matter may be adjourned for the day, lordship. Matter may be adjourned for the day,
You want an adjournment?
lordship.
It's 2019 matter.
Lordship, today I
Thursday.
brought in another file, that's why.
Thursday. That will be
Put to the.
6th.
Earlier interim order may be continued. Earlier interim order may be continued.
So this is not a. You take a choice decision. The earlier bail order was without any limitation. Now you want it to be a limited order till the next week, till for 2 days only? No, Make a choice decision.
Right.
Okay.
Much of it.
Item 27.
May I please? Lordship, this writ petition is SL against the opinion dated 24/7/2018. The impugn order is at page 36.
Yes.
Lordship, the learned tribunal below only on adverse opinion, adverse inference, the opinion is framed, Lordship.
Yes.
Lordship, in this case, Lordship, the father of proceeding himself adduce evidence.
Where is your voter list, first voter list along with your father, or any document along with your father?
Father document, Lordship.
Any document which you have along with your father?
Lordship, page 28.
Yes.
Vernacular at page 39, Lordship.
It is your grandfather, father and mother.
Lordship,
We are asking you, do you have any document of yours along with your projected father? Where is the Gambura certificate that, Gambura certificate, where is that? Which page?
Lordship. Gavura certificate, Lordship, as page 22, Lordship.
20?
2. Lordship, pardon, page 32, Lordship, Gavura certificate.
Having read this page 32 and 33,
32 and 33, Lordship.
what do you say? Do you believe it?
Pardon?
Having read page 32 and 33, do you believe in its contents?
Pardon, Lord.
You have read page 32 and 33.
Lordship.
Do you believe in the contents? And can we say lock kar diya jaye?
Lordship.
Correct. Then you have no case. You come to page 9. Paragraph 5 and 6. Your father resided, father's name is so-and-so. He's appeared in the voter list of village Negur Kata,
Lordship.
correct? And then opposite party got married. Paragraph 6 is Chanmia at village Negur Kata, correct?
Lordship.
You have nowhere written that after marriage you lived in village Majgaon.
Lordship.
This certificate at page 32 says that you are a resident of Majgaon.
Lordship.
End of the matter. You don't reside there. It's a false certificate. There's no other document to connect you.
No, Lordship, the Gaubura also deposed evidence, Lordship, and the father of the procedure also deposed.
Can there be an evidence contrary to the written statement and the page 32, 33 document? 33 document, the Gaubura says that yes, I know her. She resides in my village.
Lordship.
You have never said that you have left your marital home and you are residing in another village. It's not your case. And that's why we asked you whether we will lock it. You said yes.
Lordship, it is only the advocate who has drafted the
Oh, we don't
written
know.
statement.
You see, we have a habit of always referring to the council as learned council.
Lordship.
So unless you show us that this, what do you call, the prefix to council can be withdrawn, he'll continue to be learned. Nobody has said that you remove that word from there.
Lordship, it is fact that in her written statement, she has not mentioned the reason of her seeking.
No, not that. We are not asking about the reason. You have never pleaded that this petitioner resided in page 32 village, that is 33 village, that is Majgaon.
Malgaon.
Then you see this certificate is dated. We can't read the date. 34, page 33, please,
34.
sorry. Something I couldn't read. Page 33, please, sorry.
34, 19. That is not
No,
eligible.
that is not 19. Okay, whatever be,
Sorry.
whatever be,
Lordship, kindly use the page 34, Lordship.
So which certificate is right?
No, sir, Lordship, her husband was a president of Goribanda.
No. This is- Again, the same question. Can we lock it?
Lordship, Procedural was married to the Sanmia of president
No,
of
no, this-
Goribanda.
I don't know. We take it that this is an authentic document, page 34. Now you see this, your, come to your writ petition.
Lordship,
Now this time you can't say that the lawyer has made a mistake. That's why you are catching you here at page 7 of the writ petition. Page 57 is the affidavit. Your age is 57 years. Correct?
Lordship,
So this can't be a mistake of the earlier lawyer. 57 in 2018.
Lordship,
That makes her date of birth in 1961. Now come to page 34.
Lordship,
This is 2015.
Lordship,
This will make her 54 years of age. In the certificate is 39 years. You do the arithmetic, same thing. And we may be wrong. We are very bad in arithmetic. And in your written statement, you don't say anything.
Lordship,
When did you shift to Golibanda? That is not there. Paragraph 6 of your written statement at page 9. You vaguely say that you shifted there. When you don't say. And then there is a second reason why this document is false. You first say that you are a resident of village Majgaon
Lordship,
and you married to a person whose residence is at Nagur Kata.
Lordship,
Now, how can this Gaonpura Majgaon give you a certificate that you are resident of Golibanda? Husband residence is Golibanda. If he knows you, he give this certificate that he was married there. And your date of marriage is 1/3/1994 to so and so's son of Golibanda. You never said that. Your pleaded case is that you are married to Negur Kata village.
Lordship, originally the husband,
No, we don't know original or duplicate or triplicate.
thereafter they shifted to Golibanda, Lordship.
But look at the certificate.
Lordship,
Specific date. Got married on 1/3/1994 to so and so of Golibanda.
Lordship, in page 34 certificate, it is mentioned that has now migrated from the said Panchayat from the above mentioned locality by virtue of marriage.
You will certainly is right or wrong, we accept it as right. We have got no grievance, we are not doubting this document. We accept this document to be true, but if this is true, then your written statement is false.
In written statement also, Lordship,
Written statement, page 9, paragraph 6, very clear.
last sentence, Lordship, thereafter the family member of opposite party shifted to village Goliwal, Lordship.
We understand that. We take note of it. We have told you earlier also. But whether this is same as stated in your page 34, if you say we accept it. So this Secretary of Gram Panchayat
Lordship,
knows more than you. You don't say in your written statement your date of marriage. And this secretary remembers you. Very specific date, 1/3/1994.
Lordship.
I was know something very interesting again. Come to page 17.
Lordship,
Look at the cross examination.
Lordship,
My marriage was solemnized at Lengurkata. Where
Lordship.
you get this?
Pardon, Lordship.
We don't know yet. We are merely repeating what you have said there.
Cross, I was born at village Masgaon. My marriage was solemnized at Mengolkata, where my husband was residing. About 21 years later, my family shifted to village Goliwal.
Incidentally, before evidence, his father and son did not talk together. The name of 5 sons, which the father says,
Lordship.
is spelled differently than what the proceeding says about brother's name. Doesn't match. First name is same, but the second name, there's a mismatch. Look at your father's evidence and your evidence. There's a mismatch.
I know how to achieve its plan into the Lordship. Dilbar Ali, Ahmed Ali. Ahmed Ali. Nazrul Islam, Nurul Islam. I know Nazrul and Nurul Haq. Nurul Islam.
Please, Your Lordship, regarding item number 22, my lord, can be on 7th, my lord, Thursday. Can be on 7th, my lord, to speak for tomorrow, my lord. I have adjourned the matter. 22, Thursday. Simply of that.
So then we'll keep it on 27th.
My lord,
We'll keep it on 26th is a Tuesday. We'll
Tuesday,
keep
my-
it then because these few days there are not many official works we have to do. There's some administrative works, even the Itanagar building is coming up. So we will not be able to really hear it. Maybe
Maybe
26th. We're making 26th August.
my lord.
Then Mr. Sharma, we are finding a disconnect. If these documents go, then we find there's a disconnect.
Yes.
Your witnesses were perfect. They were more steady than you. You created problem everywhere. My esteemed brother was reading it and found out. You've seen your cross-examination. Page 17. Please read this again. It is interesting. I was born at village. Please read it again. Yes, loudly.
Oh.
I can.
I was born at village Masgaon. My marriage was solemnized at Lengurkata, where my husband was residing. About 21 years later, my family shifted to village Golibanda.
Okay.
During my childhood, my father's family shifted to Lengurkata from Masgaon.
Good. So therefore, 21 letters to your marriage. Your marriage is in 1994. Correct.
No, Lordship, about 21 years later,
21 years later of what?
later,
No, later. Later means later of what? Later to your marriage. Your marriage is 1994. 1994 and
no,
then
Lordship,
21
nothing is
years.
mentioned about whether
We don't know.
after marriage or
We are just reading your English. 1994 you got married. 21 years later would be 2025. You must start looking, you must start regularly doing English movies. Back to the Future.
No, Lordship, nothing is mentioned whether it is after marriage or after her
After
birth.
childhood, nobody will say 21 years later, I shifted to so and so. That means referring back to her date of birth. 21 years later. It doesn't say at 21 years of age. But if this is so, whatever be, whatever you think. But then come to the certificate again. And then the examination of this witness. This page 23,
Lordship,
I have issued a certificate to Halima Khatun, Exhibit F, as a
Lord.
daughter of Hatem Ali.
Hmm.
I heard that daughter of Hatem Ali, so and so was born at Mazgaon.
Lordship,
So here's the evidence.
Yeah.
Now, if your marriage was where marriage was as Bengur Kata, then your statement is false. In your written statement, you say I was married to Mazirgaon. The evidence is husband belonged to Mazirgaon. That is why before Mr. Sharma,
Lordship,
before retiring for lunch,
Lordship.
we had said whether you heard it or not. English must be seen. These are very interesting. One is two lies. It doesn't say false, it says two lies. Because every statement is made on oath. You say you are married at Mazirgaon. Your witness comes and says you are married at Gangurgata. All are true.
Certificate says he married at a Golibandha.
Golibandha.
Yes.
Marriage is Golibandha. Well, you have tried your best, but you're not satisfied. Yes, Mr. Sharma.
Lordship has already pointed out, Lordship, and if Lordship assumes Lordship the person whose name is reflected in the 1956 voter list is the father of the proceeding who adduced evidence before the concerned tribunal, Lordship, then Lordship, his citizenship itself is doubtful because Lordship, since 1970 to 2005, there is a huge gap, Lordship. What happened to his fathers during this period, that was also not mentioned, Lordship.
No, he has said somewhere 1970 father died.
No, Lord. Father
So-
adduced evidence, Lordship. As
Oh,
DW.
father gave the evidence. Ah, yes.
Lordship.
No, but somebody died in 1970. Who died?
No,
The grandfather.
after 1970, that was mentioned, Lordship.
Okay, so that is the difference.
Yeah.
Your first voter list was on which year?
1965.
No, your.
My own 1993,
19?
93, I have been in the records. Yes, sir.
But you see, with reverse calculation, in 2018, you were 57 years. So you were born in 1961. At that point of time, 21 was the age of adult suffrage.
Yes.
So therefore, 1982. So from 1982 to 1993, it's an 11-year gap. But Mr. DK Sharma, Mr. HK or DK Sharma? Mr. DK Sharma, petitioner. Also heard. That's from Islam on behalf of AIAD. Next. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has this petitioner, namely Halima Mia alias Halima Khatun, has other way. Take it other way around. Halima Khatun alias Halima Mia has assailed the opinion dated 24/7/2018, passed by page 36. Or thereby declaring the petitioner to be a foreigner of post 25/3/1971 stream. No, you say foreigner under section 2 within bracket small a of the Foreigners Act of 1946. And thereby, comma, the reference was answered in the affirmative and in favor of the state. Next one. On next paragraph, upon receipt of notice of the proceedings, comma, the petitioner had appeared before the said learned tribunal and had filed a written statement denying that she was a foreigner and projected that Hatem Ali, Hatem, Hatem Ali, her projected father was a citizen of India and brought up at village Majgaon, Majgaon, Moza Bhawanipur, in the district of and under police station Borpeta, or the then undivided district of Kamrup. And he was presently residing at village Golibanda, Golibandha, Moza Paka PAKA, PS Sorthebari, in the district of Borpeta. It was projected that the name of her father appeared in the voter list of 1966, village Majgaon, and the name of her grandfather also appeared in this voter list. Grandfather, comma, namely, comma, Ismail Hussain, ISMEIL, Ismail Hussain. And the name of the mother of the petitioner, comma, namely, comma, Jaliman, JALEMAN, Nessa. Apostrophe S also appeared in the said voter list. It was stated that the name of the parents of the petitioner also appeared in the voter list of 1970 at village Mazgaon, and that her grandfather had died before 1970. And thereafter, the father of the petitioner had shifted to village Negurkata, Negurkata, in the PS Tamilpur in the district of Baksa. In the present district of Baksa. Petitioner projected that the name of her father appeared in the voters list of 2005 of village Negurkata, Negur, Negurkata, on district Baksa, in the bracket BTAD. That the name of her father is also invested in the voter list of 2010 of the state village. Next, the petitioner projected that she had got married to one Chan, CHAN, Chamia, MIYA, son of Hekim Ali, HEKIM Ali, of village Negurkata, MEGURKATA, Moza Kumari Kata, and a PS Tamilpur in the district of, in the then district of Nalbari. And the name of the petitioner along with her husband appeared in the voter list of 1993. The petitioner projects that in the voter list of 1993, her name was treated to be Halima, HALIMA Begum, instead of, in place of Halima Khatun. That both are names of same person. So it was reiterated that the referring to the voter list of 1993, it was stated that the name of the petitioner was written as Halima Begum in place of Halima Khatun, and both are same person. So it was projected that the family of the thereafter, the family members of the petitioner's family had shifted to village Godibanda, GULIBANDHI, from village Negurkata, NEGURKATA. Her name was shown as D voter in the voters list of 1997. It was also stated that the name of the petitioner is written as Halima Mia in place of Halima Khatun, and they're both the same unknown person. Methodically relying on the Gambra certificate of village Mazgaon, Gambura certificate of village Negur Kata, and Gambura and certificate of village with certificate of Gambura of village Gori Bandha. It has been stated that the allegation against the petitioner is false, baseless, and concocted. First, along with the written statement, the petitioner has enclosed photocopy of the voters list of 1965, or 1970, or 1993, 2005, and 2010. And Gambura's first appeals, Gambura's certificate of village Majgaon, MAJGON, village Negur Kata, and village Koli Bandha. Expert. In her evidence on affidavit, the petitioner as DW1 has reiterated the statements made in the written statement regarding the name of petitioner's father and grandfather, which appeared in the voters list of 1966. The name of her parents appear in the voter list of 1970. The petitioner in support of his her evidence has exhibited the following documents. Page 15, A to H. Next one. The petitioner has also examined one Sri Dharani Kalita. What is the RMO? Page 20. Where I am RMO.
RMO.
RMO means
RMO. RMO.
who was stated that he was serving as where he was serving as RMO as election officer, Bajali, BAJALE. He appeared before the learned tribunal and compared and proved in original of the voter list of the year 1965 and 1970 and stated that in the voter list of 1970, name of Mali appeared as Atam, HATAM, Atam, the son of Ahmad expired. The petition is also examined one Ayub AYUB, Ayub Nabi NABI. Was the then Gaungura, government Gaungura of charge CHRG, charge number 2 and 1, who had issued a certificate within bracket exhibit F to the petitioner. And he stated that he had heard that the daughter of Atem Ali was born in the village Mazgaon. First of his cross-examination, he had stated that he had not prepared the carbon copy of the certificate. And also submitted that he had not produced the document in regard to the issue of certificate. Next. The petitioners also examined one Mohammed Atem Ali, a projected father is DW4. he stated that the petitioner was his daughter. And he had 5 sons, namely, number 1, Darbar Ali, DAR. Number 2, Hamad, HAMAD, Hamad Ali. Number 3, INOL, Haq, HAQE. 4, Nurul Islam. Number 5, as well as another brother named Nurul Islam. And he had stated that he has 2 daughters, namely Halima, within bracket Proceedy, he had stated that he has 5 sons, namely 1. Oh no. And he also had 2 daughters, namely number 1, Halima, within bracket Proceedy, and Habiza, Habiza, Habiza Khatun, the younger daughter. He had stated that his elder daughter, within bracket IE, petitioner, bracket 2, most of his marriage was solemnized with Sandu, SANDU, alias San, 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 Mia, of village Kolibanda, GALIPENDHA. He had referred to the name 4 sisters and 3 brothers. Now, process examination, she has also stated that she had shifted from village Masgaon to village Nengur, NENGUR, AATA, and under PS Tamilpur, present Baksa district. And that she was born and brought up. She was born at village Masgaon. He had exhibited a voter identity card within bracket exhibit I1. The learned counsel for the petitioner has submitted due to certain minor discrepancies in the name and age of the petitioner and our witnesses. Defense of the petitioner was dejected and he was declared to be a foreigner. So it is also submitted. The learned travel had dismissed had rejected the claim of the petitioner of being a citizen of India on technical ground. And the evidence of the petitioner was doubted because of shifting of her residence and that the names of her siblings do not appear in the Gambura's. Accordingly, by drawing adverse presumption against the petitioner, it was held that the petition and proceedings. The witness is examined, cross-examined by the prosecution, and their cross-examination corroborate the evidence of chief. And no contradiction could be brought out. According statement that the petition be dismissed. Next. The learned standing counsel for the FP matters has opposed the prayer made in the petition and has supported the opinion of the learned tribunal. Yeah. The travelers appears to be correct in its appreciation of the three certificates being exhibit. Okay. Yeah. Counter certificate. It dated 34 2019. Certificate dated date nine. 31 5. 31 5 2017. Issued by Sri Nobin Rajbongshi, NOPIN, RAJ, PN, PNG, etc. In charge lot Gampura. And certificate dated 2016, issued by Sri Dhoniram Roy Gampura. Stating that the petitioner was a person from his village and that the name of petitioner's father and mother appeared in the 46 number Kurukhetri Legislative Assembly constituency of 2015. And that next one. Therefore, from exhibit F, the petitioner was a resident of village Majgaon, having married to Hatem Ali, resident of Majgaon. As per exhibit G, or the Gampura certificate dated 31/5/2017. The petitioner was an inhabitant of village Limburgata, Lengurgata, and that as per certificate dated 11/11/2016, exhibit H. Now, the petitioner was a resident of Golia Banda, GOLIABANDA, being married to Chandu of the said village. If the evidence of the petitioner was believed, the petitioner come in a cross-examination had stated that a marriage was organized at Limpur, Qatar, where her husband was residing. And about 21 years later, her family shifted to Islamabad. Kalibanda, Kalibandha. And he had stated that during her childhood, our father's family had shifted to Dengu, Qatar, from Majgaon. The marital home appears, the petitioner appears to be at 3 locations. The contents of this, the contents of this certificate had taken at its face value appears to be a mismatch with the statement made by the petitioner. Because as per the contents of exhibit it should be to this page 34 is not an exhibited document. Page 34 is not an exhibited document. Page 34.
No, Lordship. No, it was not exhibited. No.
One second. In this case, the as per the projection made by the petitioner in this petition, as per the affidavit sworn in support of the petition, petitioner was 57 years of age. On 3/10/2018, when the affidavit was found, it makes her date of birth, the year of birth, it being 2018. and therefore, sorry, it was 1961, and therefore let's put the age when person would then have exercised the right to franchise being 21. Petitioner was entitled to vote on or after 1982. Our name appears in the for the first time in the voters list of 1994. With this no exclusion of I name the petitioner did not exercise a right to franchise on or immediately after 1982 till 1990. As per the when was that 1944 marriage? Let me just set it. Where is that 1994 year of marriage? Where was that? Okay. In this petition, the petitioner is annexed a copy of a certificate issued by the secretary of 108 number Majgaon, MAJGON, Gaon Panchayat, wherein her date of birth is referred to as 1/3/1994. So, if the contents of the said certificate is conjointly read with the cross-examination of the petitioner as PW1, DW1, she had stated that marriage was solemnized in the solemnized at Lengur Kata, LENGURKATA, where her husband was residing. And about 21 years later, her family had shifted to village Gulibanda, GALIBANDHI. Stop. Therefore, you therefore the said statement makes the petition to have shifted to village Golibanda in the year 2015. And accordingly renders the contents of exhibit, sorry, Congress certificate at exhibit F and H as false, being inconsistent with the claim of the petitioner. Hmm. In respect of Exhibit G, which is a Gaunpura certificate dated 31/5/2017. There's a footnote by the Gaunpura to the effect that the petitioner was a resident of who was a resident of village Lembur Kata, but was then a permanent resident of village Golibanda. It said such statement is to be inconsistent with paragraph 6 of the evidence and affidavit by the petitioner, wherein it stated that he got married to Chandnia of village Negurkata, Negurkaata, and the name was enlisted in the voter list for 1993. Her name was written as Halima Begum in place of Halima Khatun. And she had stated that thereafter her family shifted to village Kolibanta. For the shifting of village, 21 years of marriage, not the projected case of the petitioner in her evidence on affidavit. Ordinary respect. What's this? If the petitioner has not been able to connect herself to a projected father, namely Hatem Ali, insofar as documents are concerned. Next. Expected to go from Hatem Ali who came as it proposed that speaking to Pope, give a name of the his sons, the siblings of the petitioner. And therefore merely by the full evidence. The project father of the petitioner has not been able to that the petitioner is a daughter. Spending its cross-examination. Father could not say the year of birth of the petitioner. Next, on evidence of the four witnesses examined by the petitioner, including herself. Yes. If the evidence is vague insofar as the management the shifting is concerned. Resulted at the comma. As the evidence of the tendered by the petitioner is not consistent with that of the projected father. And also of the deputy 2 and 3. What is in fact what that the petitioner has not been able to show that not been able to show that the opinion rendered by the tribunal is initiated by wrong application of pleadings, evidence on record. Or that while rendering the opinion of petitioner the tribunal had relied on certain extraneous materials inconsistent with the record. I get the wrong conclusion. Next, accordingly, the court is inclined to hold that the petitioner has not been able to discharge a burden under sections 9 of the Partners Act 46 and failed to prove a linkage with the projected father. Next, is it that's dismissed without any interference with your opinion. The excellent theory. Next, the records of the tribunal will return along with the copy of this order to be made a part of it.
RMO is Romeo machine operator. RMO, Romeo machine operator. Romeo machine operator.
Romeo.
Romeo.
RO.
NEO.
MEO, Romeo.
Meeting operator.
That RMO, that RM, full form is Romeo, ROMEO, Romeo Machine Operator. This is a correct description.
Yeah.
Because we were thinking it could have been record. What do you call? Maintenance officer or something like that.
No, Romeo, Michael, they put me that Romeo meeting operator.
New nomenclature for us.
Okay. Romeo meeting is a duplicating meeting. Google says.
It's a duplicating method.
Yeah.
Upgraded item 40 for orders.
My lords. This is a matter of review petition along with condemnation of delay, with IF for condemnation of delay. The matter was, the final hearing of this matter, and the final hearing of this matter was held on 12/12/2023, my lords. And awaiting pronouncement of judgment, Honorable Justice Amar Pataka deleted the office, lordship. And then we have made a mention before this Honorable Chief Justice for listing of this matter, the convenience of this Honorable Court, lordship. However, I would like to pray before my lordships that my senior counsel, the engaged senior counsel is to travel from Delhi. And because of some personal difficulty today, he could not be present, lordship. Because of this, I would like to request my lords to kindly give us another date for final hearing, lordship. And then this matter also got listed suddenly, and then mass lordship. Challenging the writ lordship. Order 4/8/2021, lordship of the Honorable Division Bench in writ appeal, which was allowed by this Honorable Court, so which lordship, something was dismissed by the Supreme Court of India on in limine, lordship. Because of that, we had this jurisdiction to, this Honorable Court had the jurisdiction to take up this matter. Lordship.
One, you both have consensus, 21.
My lord, my kindly allow the next, that to be listed on 21, 21 of August, 21 and 21st of August.
The first of all.
Lordship. With the head of August, Lordship. All right. Hands up, Lordship. Lordship, with humble respect, with humble request, since it is the request of my learned senior counsel from Delhi, and then because of his time schedule, he has requested on 21 August. So if it is possible to accommodate, kindly give us time on 21st. Maybe like in the afternoon, if possible. All right, Lordship, I bow down. Lordship. Lordship. All right, Lordship. Lordship, Lordship.
Item 44.
When I go for report was being called for.
This is not exempted you. Okay, I have no. No, we have to, we form the part of the order. Uh, will be in the IA. Yes, sir.
Item 47, upgraded item.
Your lordship. Lordship, the fact of this matter is, Lordship, on last occasion, I was granted with even last occasion was granted with interim relief with the conditions to appear before the FP border within 15 days, Lordship. I failed to appear within 15 days, failing to manage the security money as well as the surety, Lordship. Hence, I never appeared before the FP border police. The relief was granted on 30/8/2023.
You're sorry, we're not able to follow you.
Lordship,
You said that you were granted bail,
yes, sir.
that is order dated 38 to the 2023.
Your Lord.
Yes, now what happened?
Like, with the condition to appear before the border police within 15
Yes.
days. Failing to appear before the border police due to the bail bond, which was of 5,000.
But you know, the statement which you have made at paragraph 6, sorry, page 6, paragraph 4, that due to some domestic issues, she could not appear.
Failing to
This is not a good ground to extend the bail for you. You'll have to, instead, we'll hear the matter. We can't extend, the actions of the court cannot be taken so lightly.
This lordship, you allow me to appear before the,
No. You have been, you have managed to be there without, for almost 2 years now, without bail.
lordship, after filing the IR, what happened is the local police, the border police, they detained my son. Not exactly arrested, but they took him.
That we don't know. But as on date, you have disobeyed the order of the court. You did not appear on time.
Lordship, I beg your pardon, your lordship. I maybe give me one chance.
It can't be encouraged.
Lordship, I'm willing to appear.
After 2 years, we don't find a good reason.
Lordship, I beg your pardon, lordship. I mean, please give one chance, lordship.
We are sorry, we expedite the hearing at first week of September. Can't extend. It's such a vague explanation, is no explanation at all. Third. Is E. Khatun. Learned counsel to the applicant. Also heard that. I finally just want to look at the application. Applicant, namely so and so, alias so and so, who is the petitioner in the connected WPC 5012/2023 has prayed for extension of time to comply with the directions contained in the order dated 30/8/2023 passed in WPC 5012/2023 appear before the Sovereign of Police within Packet Porter, Packet South Salmara, Mankachar, and to take bail. Next part. Next, one of the reasons assigned by the applicant for not being able to appear and take bail before the Superintendent of Police border South Salmara - Mankachar is that there were some domestic issues for which she could not appear. The second ground assigned is that the applicant being poor, naive, and studied only up to class 4 was completely oblivious of the nitty-gritty of the legal procedure and not aware of the circumstances, he did not approach this court. All this while. Next one. Both the reason assigned are not found to be good or not for the applicant to have not taken bail in compliance of the order dated 38/2020 passed in WBC 5012 of 2023. Full stop. Before this court, the applicant was represented by a learned counsel and it is not the case of the applicant that her learned counsel did not give her the copy of the order or advise what to do after receiving copy of order dated 38/2023. Therefore, vague plea that there were certain domestic issues for which he could not appear before the said police authority and take bail. Cannot be accepted as a good ground for not appearing and take bail. And next, the circumstances of the court is disinclined to extend any further time to the petitioner to the applicant to appear before the Superintendent of Police within bracket Portler, South Sarmana Manchester, and to take bail. Next, power, as the connected petition is pending for hearing. It is provided that in the event the petitioner, namely Masuda Begum, alias Masuda Begum, is apprehended, he shall not be deported out of the country without proper report. The connected petition is that
Well, thank you very much for the consideration. I have discussed the next step with the respondent counsel also and my senior also. And we have decided to take the matter on 11th September if my lordship will be pleased. 11th September. Lordship.
Next.
Lordship, please.
Upgraded item 34.
Advocate clearly in the criminal portion. I'm just calling.
Lordship, we are supposed to file affidavit, Lordship. Some communication has been made, but still the instruction has not been yet, Lordship. 1 week time may be allowed, Lordship.
This is G. Sharma, and standing question for the active matters raised for 1 further week's time. Current affidavit in terms of order dated 21/7/2025. This form. 13/8, 13/8/2025.
13/8.
It's playing for time, 13/8, we are fixing.
13/8.
We'll not have time to take up any other matter. No?
I don't know if any date can be given by or number of occasions I can.
This will continue for quite some time. So this is.
Any convenient document, I'm not asking for immediate. It's not the. NCR is also the issue.
Because it, whatever date we fix now will only be after, okay, he'll check it out.
Published.